Good morning and good afternoon, everybody, and welcome to the latest edition of the ASHBUR webinar series. I am going to be your presenter today, Stuart Otto, that is my name. And today, what we're going to be presenting on is the Shelter Standard and the Minimum Monthly Maintenance Needs Allowance, and specifically how those two variables impact the spousal plans. So this might be a little bit of a trip back down to the basics here of Medicaid planning, but I figured with the July updates to the Shelter Standard and the minimum MMNA, this would be a good time as any to revisit these variables and see how they impact planning, because there's a lot of different ways they can really impact planning for the benefit of your clients. So before we go ahead and get into that, let me go ahead and introduce myself. For those of you that don't know, or this is your first time on the ASHBUR webinar, I am going to be your host, Stuart Otto, and I am a Medicaid planner here at ASHBUR. I've been with ASHBUR for just over 2 years, and I have been in the industry overall for about 11 years, providing crisis Medicaid planning and Medicaid compliant annuities for elder law attorneys and their clients. So if you ever have a case where you have a spend down with a Medicaid potential Medicaid applicant, and you want to get my advice on that, please feel free to do so by emailing me at stuart@ashbur.com or calling my direct line, which is listed there as well. And again, if you're new to the ASHBUR webinar series and don't know who we are an annuity company that specializes in crisis Medicaid planning and Medicaid compliant annuities, and particularly the short-term Medicaid compliant annuities. This is what we do on a day in and day out basis. It's what we specialize in. And with that, we offer complimentary planning assistance and spend down support. So we'll run all the calculations for you, the proposals, whatever you need to get your client on board with doing a spend down with an annuity. And then on top of that, the insurance carriers we work with are A-rated for the MCA. And then we have over 15 years of experience in the industry, going pretty close on to 20 years. And I think overall between the staff here, between myself, Amber, Jessica, and the rest of the staff, we have about a combined experience of 40 years. So definitely a lot of experience and background in this type of work. And as I mentioned, our primary product line is the Medicaid compliant annuity, but we do also offer a few other products, primarily for crisis Medicaid spend downs as well. One of them is going to be the irrevocable funeral trust. We also offer a single premium whole life insurance policy that's a guaranteed issue contract. We offer tax deferred annuities for crisis planning and also for pre-planning as well too. Tax deferred annuities can be a beneficial tool for, particularly in the state of Texas, with their rules pertaining to IRAs and funding IRAs in tax deferred annuities. And then on the pre-planning side, we do work with long-term care insurance as well too, and help provide clients with the insurance that they need to maybe try to avoid a crisis situation in the future, use it as like a way to protect an estate plan that you might have for the client. So long-term care insurance is something we offer as well. And in addition to the products, our services, I already mentioned with you the complimentary case analysis and the spend down support. We do also offer the Medicaid annuity quotes, as well as the application assistance. So essentially whatever you need and whatever the client needs from us to get the annuity in place, that's what we're here for. And then after the annuity is issued, we provide a lot of support after the fact as well. So any changes to the account that you need to make, you run through us. If the client passes away, we work hand in hand with all the parties involved, the state, the insurance company, the law firm, and the client, in getting that death claim settled in a timely manner and convenient manner as well. And then if there's ever a denial for your client on a Medicaid application as a result of our annuity, we do provide fair hearing support and testimony for that. It's not something we've had to utilize yet, but it is there, and it's provided free of charge as part of using our services. And then lastly, we have online resources as well where you can access all of our information at ashford.com. Particularly if you wanted to rewatch this webinar, you can do so on the website, or also past webinars. They're available on our website as well. We have case studies for the types of cases that we work on. We have state Medicaid guides for all 50 states and the District of Columbia. And then in addition to that, we also have intake forms. So if you have a potential client that may need an annuity, you can fill out one of our intake forms and submit that case online as well too. We have a portal there for you to submit all that information. And then on social media, we're available on LinkedIn, Instagram, Facebook, and YouTube. And just to note that our webinars are also available on YouTube as well too, if you want to use that platform as well for the webinars. And all of this information is available free of charge. There's no requirement to sign up for anything. That's all available for you to access at any point in time. All right, so let's go ahead and dive into the July Medicaid updates. As you may know, last month, the new numbers were published for the Shelter Standard and the minimum monthly maintenance needs allowance. There are essentially 3 different numbers for each that are applied. Alaska and Hawaii have their own separate numbers that get updated. We're going to deal primarily with the continental 48 states with what those numbers are in our case examples here. So as you can see, the Shelter Standard has been updated to $793.13, and the minimum MMNA has been updated to $2,643.75. All right, so let's go ahead and define these numbers, or these variables, excuse me. The minimum monthly maintenance needs allowance, which I'm going to primarily refer to as the minimum MMNA, because that, you say monthly maintenance needs allowance over and over again, that can definitely be a mouthful. So yeah, I'm going to say minimum MMNA as much as I can. This is essentially an income standard that is allotted to the community spouse that says what he or she is entitled to for income. It is not an income limit, it's an income standard. So it's something where if the client doesn't have enough income, then we need to do something to help them meet that standard, give them enough income to be comfortable in the community. It is not an income limit, can't stress that enough. And the Shelter Standard is a variable provided by the government that is used in determining additional income allocation to the community spouse based on shelter costs. So we're going to get into this a little bit, but the Shelter Standard really comes in those states that have both the minimum and maximum MMNAs. Essentially, the Shelter Standard will allow you to adjust that MMNA number, because that number can be variable going from one client to the next. Here are some of the shelter costs that are typically included with the community spouse. So anything like rent or mortgage, that's typically going to be included as a shelter cost. Property tax allocated on a monthly basis versus the typical annual basis. So whatever your annual property tax is, divide that by 12. That will be what they'll allocate as the shelter cost for your client. And then any maintenance fees for living in like a condominium or HOA, that also gets counted in. And then also the standard utility allowance, which is another number you're going to find on your state Medicaid guide, which essentially gives you a default number to use for all of your Medicaid application cases. You're not going to have to round up every utility cost that your client pays on a monthly basis. They're just going to give you whatever standard that is, and then you're going to use that. So it's a lot easier to calculate instead of having to run down the water bill, the electric bill, phone bill, things like that. So we talked about the income for the community spouse a little bit. I want to stress that when it comes to eligibility for the community spouse, there's really no income limit at this time for the community spouse. So they could have $10,000, $15,000 per month in income while their spouse is on Medicaid. That may not always be encouraged to have that much income, but it is definitely something that they are entitled to because there's not necessarily an income limit per se. However, we're going to kind of deal on the other side of the aisle here, where if the community spouse does not have enough income to meet whatever his or her MMNA is, then the difference is going to be made up through the institutionalized spouse's income. So that's how they're going to bridge that gap. So as a result of that, and this works kind of like a domino effect, when the institutionalized spouse transfers that income to the community spouse, it's going to reduce his or her Medicaid copayment and thus increase the monthly benefit. So utilizing these tools can definitely help you increase them and maximize the monthly Medicaid benefit that your client would be entitled to. So let's talk about the Medicaid copayment for just a little bit here, because it's another variable that's obviously impacted by the shelter and MMNA figures. So this is essentially the amount that is owed to the nursing home every month once a Medicaid applicant is receiving Medicaid benefits. Medicaid copayment doesn't come into play until you're on Medicaid. But this number is always indirectly impacted by the MMNA and the Shelter Standard, as I mentioned. Typically, the calculation is just simply taking the Medicaid applicant's income and subtracting things like Medicare Part B premiums, supplemental insurance, and then also the personal needs allowance, or the PNA. That is a state-specific number also provided to essentially allot them X amount of dollars per month to spend on their personal care or their non-medical expenses, basically. This number is not very high. I would say it ranges anywhere from like $30 to maybe $150, depending on what state you're in. But more so, it's probably between like 30 and 70, 30 and 80. And this number doesn't often change from year to year, but it is something that is there that the client would have the ability to utilize if they choose to. And then back to the calculation here, if for the Medicaid copayment, as I mentioned before, if the community spouse's income is under the MMNA, then there'll be an additional deduction included in that calculation to further reduce that Medicaid copayment. So in order to kind of identify how to calculate one's MMNA in a particular state, I think we have to take it back and look on a national scale here, because I'm presenting to attorneys that are all over the country. So I want to make sure this is applicable to everybody. So the best way I've always done this is dividing the states up essentially into like two different categories. You have states that utilize one MMNA, and then you have what are states that are basically referred to as minimum maximum states. So the max states that's listed on the top there only applies one standard, and typically the minimum MMNA and the shelter standards are not even in play with these states. These states are typically easier to work with these calculations because you don't have to go through the process of gathering up the shelter expenses and then comparing that to the shelter standard and then going to the MMNA and trying to calculate that. They typically just give you a flat number for every single client. And then the minimum maximum states are the ones that are going to have what I would refer to as a range of MMNA possibilities. So the minimum MMNA is the $22,643.75, and the maximum is $3,984. Your client's MMNA on a case-by-case basis can fall anywhere between that range, depending on what their shelter expenses are. And so these next two slides are just lists of states that are basically your minimum maximum states and your max only states. So as you can see, the majority of the states are going to be minimum maximum states, and we do this calculation on essentially a daily basis, so, or on a per client basis. So one more slide here before we start to get into the case examples. As I may have mentioned, this is going to be kind of a heavy case example presentation here. So how do we go about determining the MMNA in a state that has a minimum maximum range, basically? So as we know, the community spouse is entitled to the minimum MMNA plus any additional or excess shelter expenses. but we cannot have it exceed the maximum. So like I talked about before with the range, from the minimum to the maximum. So essentially the shelter, excess shelter expenses or shelter allowances means that expenses above the state's shelter standard of the $793.13. That remainder is going to be added to the minimum MMNA to get our real MMNA for that particular client. So again, as I mentioned, we take the shelter costs, add them up, subtract what the shelter standard is. And again, if that figure is positive, then it's added to the minimum MMNA. If that figure is negative, then the community spouse still receives the minimum MMNA. All right, let's go ahead and dive into our first of many case examples here. I always feel that's the best way to kind of articulate this stuff and show kind of how it works, like kind of in motion here. So we're going to work with a couple named Robert and Nancy, and we're going to work with them throughout all of these case examples. These are going to be very comparative from one another, so you can kind of see the differences between one state to the next. States that use max only, states that have a minimum maximum, or situations where you're only using the minimum. So let's look at the first example here of a max only state. These are the easiest to work with. So we have Robert and Nancy, and they're married. They reside in the state of Georgia. Georgia is going to be our guinea pig for this example here. Robert is in the nursing home. Nancy is the community spouse. Robert is on Medicaid. His income is $3,500. Nancy's income is $1,000. And then at the bottom here, it's not going to be applicable for the first two examples, but the bottom, I do have HOA fees of $300 per month, and then property taxes allocated at $300 per month as well for the shelter expenses. Okay, so for this particular situation, we always want to find out what the MMNA is first. So in a max only state, we already know that the MMNA is the $3,948. So with that, we know what Nancy's entitled to, the $3,948. However, we know that Nancy's income is only $1,000. So Nancy's shortfall is $2,948. So that difference, that $2,948, is going to get taken from Robert's income on a monthly basis and transferred over to Nancy. In addition to that, Robert is going to allocate $70 for his personal needs allowance for him to use for himself for his non-medical expenses, basically. And so that's going to leave Robert with a Medicaid copay of $482. And so again, to recap and re-illustrate that in Georgia and in any max only state, the community spouse is entitled to the maximum of $3,948. But because her income is only $1,000, she's short $2,948. So that again is getting transferred from husband to wife. And that's going to result in the community spouse's income, in this case, increasing to $3,948, resulting, like all of these examples will, in a smaller Medicaid copay and a larger Medicaid benefit. Example number two, we're going to look at the opposite end of the spectrum. We're going to use the minimum MMNA in this situation. Now, I'm going to hold every other fact of the case constant, except I'm changing the state from Georgia to Alabama. Essentially, we're switching from the Eastern to Central time zones, I think. But Alabama's the one state that is, I would technically classify them as a max only state. However, their maximum is the minimum MMNA allowance. So they're the one state that has that unique distinction to my knowledge. However, this example is also going to apply to any minimum maximum state where your client's MMNA is going to be calculated as the minimum. So anytime we're using 2643.75 for our clients for the MMNA, this is going to be applicable to you. So because Nancy is in Alabama, as we know, her MMNA is $2,643.75. So with Nancy's income of $1,000, she's still short. She's still entitled to a transfer from Robert, but this time it's only going to be for $1,643.75. So again, that's going to get subtracted from Robert's income of $3,500 and moved over to Nancy, as well as the $30 personal needs allowance for Robert. That's going to get allocated to him as well for his personal needs. So that's going to give Robert a Medicaid copay in a situation of $1,826.25. So again, in Alabama, the community spouse is automatically entitled to the minimum MMNA of $2643.75. But again, any other state that also allocates the minimum MMNA, this is very applicable to. And then because her income's only $1,000, she's still entitled to that transfer. And so as a result of all of this planning, the CS's income is increased to $2,643.75. Excuse me. Notice that that is much shorter, much lower than the income that she would have received had she been in a max-only state like Georgia. So it still does result in a smaller Medicaid copay and a larger monthly Medicaid benefit, but it does show the significant distinction between Georgia and Alabama. So I could always see a scenario where maybe you're on the Georgia-Alabama border and you are licensed in both states. You're comparing whether or not it would be beneficial to have an applicant reside for a community spouse case in the state of Georgia versus Alabama, because you're getting a significant benefit from that. And that's applicable all over the country too. If you're on border states, like Missouri and Kansas is a common one, or a lot of East Coast states, comparing and contrasting from one state to the next, because you're licensed in both and their obvious benefits can vary from one state to the next. This is an important thing and to distinct between. So just keep that in mind when you're doing these types of plans for your clients. All right, so let's take a look at a more complex case example here. This one is going to involve the minimum MMNA or min-max state with the shelter costs included. So we're going to add a few steps at the beginning here to show you how this actually works with the shelter cost and the minimum MMNA. So again, we're going to hold everything constant for Robert and Nancy in this situation, except we are going to assume that Robert and Nancy are residents of the state of Maine. So the first thing that we're going to do, and this is different from the other ones, is that we're going to determine the shelter costs. And how we do that is by adding up all the shelter expenses. So as you note from the previous slide, that the HOA fee is applicable, the property tax is applicable. So this scenario tells me that Nancy owns her own home and there's no mortgage to pay off, but they reside in an HOA and still have property taxes to pay. So we are adding in those two costs, and then we're also adding in Maine's standard utility allowance. They do have a pretty generous standard utility allowance versus other states. So the shelter costs are going to move up to $1,675 for Nancy in this case. So step two, we're calculating the MMNA. So first we added up the shelter costs. Now we're going to calculate the MMNA. And to do that, we have to first do our calculation where we're taking the shelter costs and we're subtracting the shelter standard from that to determine if there's excess shelter expenses. And in this case, there's excess shelter expenses of $881.87. So we add that excess to the minimum monthly maintenance needs allowance, and we get Nancy's MMNA for this case, $3,525.62. That number falls within the range of our minimum and maximum because it's less than the $39.48, but it's greater than the $26.43.75. So now we go ahead and just do the same calculations we did for the first two examples. Nancy's MMNA of $35.25.62 is still greater than what her income is that she's receiving. So Nancy's shortfall is $2,525.62. And that is going to get transferred again from Robert's income of $3,500 and allocated over to Nancy. And then we're also going to allocate $40 again to Robert for his personal needs allowance. And that's going to leave him with a Medicaid copayment in the state of Maine for this case of $934.38. So as a result of that, Nancy's income is going to increase to the $35.25. And again, just like with other cases, that Medicaid copayment and that Medicaid copayment is going to go down, and the Medicaid benefit is going to go up. And I think I got a little bit ahead of myself there because that's what this slide essentially kind of wraps up. So because we're in a minimum maximum state, we do have to account for that range, the minimum, the 2643.75, and the maximum 3,948. So with her number falling at 35.25.62, she's within that range, so it's an allowable MMNA for her. So right now we're going to go into our fourth case example here, and this one's probably going to be the most complex. How does an asset spend down affect the community spouse's income? So as you know from other presentations, that this is only part of the income portion, is only part of this part of the Medicaid plan here. We still have to consider the asset eligibility as well too. The first three cases, I assumed asset eligibility already and that they were Medicaid eligible. We were just allocating the income as needed for those particular clients. But in a more likely scenario, you're going to have a client that may have excess resources here. So we're going to hold everything constant from the previous example. We're still going to use the state of Maine. We're also going to use that previous MMNA because everything else stayed the same of 35.25.62 here. That'll come into play. But the only thing we're changing is the excess resources of $100,000. So we have to find a way to spend that down. And as you know, one of the ways to spend that down is by doing a Medicaid compliant annuity. Now I'm assuming there are other options for spend down, such as making improvements to the home, upgrading the vehicle, buying those irrevocable funeral policies, whole life insurance if you wanted to. Those are, the whole life is kind of limited with their actual values and what you can do. But let's assume all that's been done. We have $100,000 excess spend down here. So we're going to take a look. We have 4 quotes here. We're going to end up analyzing 3 of them. And I'll kind of show you why, but I ran quotes at 12, 24, 48, and 120 months to kind of articulate how the MMNA is impacted with a Medicaid compliant annuity. So let's look at the short-term annuities, the 12 and 24 months. At 12 months, with that monthly payment, the community spouse's income is going to increase to $9,337.85. And at 24 months, the CS's income is going to increase to $5,171.01. So both of our options, as you can see with Nancy's income in those 2 scenarios, there is not going to be an income transfer during the term of the Medicaid compliant annuity because Nancy's income with the annuity payment is over her MMNA of $3,525.62. But if we look at the longer term Medicaid compliant annuities, at 48 months, her income will increase to $3,096.10. So with that annuity payment, she's still under the MMNA of $35.25.62. So because of that, she would be entitled to an immediate income transfer from Robert of $429.52. And then additionally, at 120 months, the CS's income is going to increase to $1,850.22. So that's going to allow the institutionalized spouse to transfer $1,675.40 over to the community spouse immediately. And they're essentially going to be able to do that for 10 years. So basically, to kind of look at and analyze those 4 quotes, the community spouse is going to receive a reduced or no transfer from the institutionalized spouse during the term of the annuity. I think that's one of the biggest things to highlight, that, you know, because the Medicaid compliant annuity is 100% income all of the time. So that income is, the more income you have, the less ability you have to utilize the MMNA rules, basically. And we can also notice that the shorter the term, obviously the quicker the community spouse's income will go down. So after that 12th month, like in that 12-month annuity, month 13, now the community spouse can apply for that MMNA transfer because her income's gone back down to that $1,000. The 120-month term offers the most immediate benefit because you're transferring $1,675.40 immediately on a monthly basis, essentially for a 10-year term. So this is going to increase the monthly benefit proportionately because of that. But with the 10-year term, one of the concerns is that obviously with every annuity, we always have to list the state as primary beneficiary. The longer the term, the longer we keep that death benefit exposed to recovery if the community spouse predeceases the term. And then the other thing too is that the assets in the annuity are not being returned to the client as quickly as the shorter terms. So that's another thing that has to be considered. There's $100,000 going into the annuity. If it comes back in 1 year, the client has the $100,000 back, ready to do whatever they need to do with it. Whereas with the 120-month annuity, that is not the case. So I'm going to break down actually on a full 10-year scale here. We're not going to go through every single year particularly because I don't think that would be prudent, but we're going to break down the MMNA transfer for the 3 primary quotes that I think would be the most legitimate options there. I took out the 24-month because that is one that is, there's no difference, there's no benefit because there's no income transfer for the first 2 years, whereas with the 12-month, you're getting that income transfer after the first year. So I took that one out for this comparative analysis here. So as you can see in year 1, and these are all annual figures here, the annual figures are calculated here at the bottom. So that's basically taking the anticipated monthly MMNA benefit and then multiplying it by 12. So in year 1, the amount of MMNA, amount of income transferred from IS to CS is 0. For the 48-month MCA, it is just over $5,100, and then for the 10-year plan, it is $20,104.80. And for that 120-month plan, this is going to be the income transfer every single year because that annuity is going to continue to pay out for the entirety of that 10 years. But after the first year, we get into month 13, we see that the 12-month annuity is expired and we can reapply for the MMNA transfer. So now the annual amount that's getting transferred, assuming everything is held constant, obviously numbers change and incomes change from year to year, so there might be slight variances here, but for the most part. So we're going to hold everything constant here for purposes of illustration. But in year 2, the community spouse would be entitled to that full MMNA transfer of the $2,525.62 that she's entitled to. So an annual income transfer for the community spouse in years 2 all the way up to year 10 is going to be $30,307.44. And as you can see with the 48-month term, that still continues to do the $5,154.24 number, and that number stays the same until we get to year 5, where the 48-month MCA expires. And now, so because there's no annuity in year 5 for the 48-month MCA, now that one is also entitled to the maximum MMNA benefit, whereas the 120-month MCA still has that monthly income. So that annual income transfer is going to be less. So for the first 3 years, if you look solely at the MMNA figures, the 120-month plan provides the best return on investment. However, when we get to month 36, that's essentially our break-even point, our pivot point, where the 12-month plan becomes better. Because if we go back a little bit, and so these numbers is 60,600 and then the 60,300. I'm going to go back and show you how I got those. I got those by adding up for the 120-month plan these 3 years. And then for the 12-month plan, I added these up. Right here, you're not getting much benefit with the 48-month plan. It's either the 1-year or 10-year plan that's providing the most benefit. So this becomes sort of that pivot point here, year 3, and particularly month 36, where that 12-month plan becomes better. And now because that 12-month plan is providing a higher MMNA transfer every single year, that is going to get bigger and bigger throughout the remaining 7 years of the illustration. And then on top of that, the 12-month MCA, the full asset of the $100,000 is returned to the community spouse. And that's drastically increasing her liquidity there. So another additional benefit to kind of consider there when doing these types of cases. And then here's the breakdown for years 6 and 10. Everything is held constant. Everything's the same for years 6 through 10, basically. What's important here is to kind of look at the totals overall. You see that 48-month plan still comes out to be better than the 120, not by much. You know, it kind of becomes a horse apiece when you drag that out over 10 years. You know, $1,500 difference or $1,400 difference is not that significant over a 10-year span, basically. But that 12-month plan definitely provides the most benefit, because you are starting that maximum income transfer in year 2 versus like year 5. So that's how that sort of breaks down and pans out. So I would say overall that it makes more sense to use the 12-month term if everything is all kosher, if everything is perfect. But there are some variables that you need to consider as far as using a term, because you don't want to get too aggressive with that. Again, you know, as we talk about in other presentations about going short or going long, don't go too short in these annuities to raise any red flags with the state Medicaid office. So I feel like you should only be using terms that you know are going to get through, or you know are or you have seen go through already. You don't want to raise any red flags. So if 1 year is too short for you in some states, which yes it is, then don't do that. You'd have to go with the longer term. That's why I provided that 48-month illustration there as well, to show that, you know, hey, maybe this is where your starting point is versus the 120-month. So don't go too short with the term. Also, if you're annuitizing a retirement account, a 12-month term might seem a little short, because you're not really doing much tax spreading, if you will. You know, a lot of times the most common terms you kind of see with these types of assets are 2, 3, and 4 year terms, kind of as starting points here. But yeah, stretching that out over a longer period of time, you know, is going to be beneficial. So that 12-month term probably wouldn't be applicable if you're using retirement plans. And then also the longevity of the institutionalized spouse. You're not going to be, if there's a short longevity, then there's not really going to be much of a benefit per se for the MMNA transfer if you do in the short term, because they're not getting that MMNA transfer in like years 2, 3, 4, 5, 6. You know, if there's a short longevity there, then, you know, then there might be, you know, there would still be reason to go short on that one, but it's something that has to be taken into consideration, because it may not necessarily provide the best economic result there. So another thing I will say here, and this maybe applies to a few states, I don't know particularly how much, but I've heard this in a couple of states regarding promissory notes and the treatment of income for promissory notes. As I mentioned earlier, income for an MCA is typically universally 100% countable. I've not heard a state that would only allocate certain portions of that annuity payment as income. However, there may be a few states that only count the interest portion of the note as income, meaning when you have a promissory note payment back to the community spouse, there's 2 separate portions. There's a portion of principal and there's a portion of interest. Usually those states will only count the interest portion of the payment of the note as income. That can serve as beneficial, because that payment right now, if you look at the applicable federal rates, is about 4%. So the other 96% is the return of principal, which wouldn't be considered countable income. So you could take advantage of a MMNA transfer there by potentially utilizing a promissory note, but I don't think that that's very common, but I think there may be a few states out there that that allow this type of strategy. And then also, I would say this is probably the last consideration here, and I do have one more case study to go through really quick, if by calculating the shelter costs and the minimum MMNA, an increase in the MMNA could also result in a expansion of the resource allowance. So there are scenarios that may come up where the combined income of the institutionalized spouse and the community spouse is less than what the MMNA is for the community spouse. If that is the case, then your client may request a fair hearing to increase that allowance. Texas is the only state that we're aware of where you can do this without requesting a fair hearing. But basically, I'm not going to get into the actual calculation of this, but like the basic calculation is like whatever the income shortfall is to the MMNA, that's going to be divided by the current CD rate. And I believe that CD rate is divided by 12, so you get a really small fractional number that is doing the dividing. So you get you essentially get a really big asset figure. A lot of times these asset figures are pretty significant because essentially what the state is saying by this calculation is that they're going to allow clients to have additional assets up to the amount that they need to invest in a CD to generate that additional income shortfall, basically. So that's essentially my understanding as to why they do that, but just note that is a possibility. So just to kind of give you a little bit of a rundown example here of this. Let's say, for example, you are in a state, and this would still be Maine, I believe. You have you're looking at a MMNA of $2,643.75. So if the IS and the CS have combined income of $3,000, that amount is greater than the MMNA of $2,643.75. So you can't do any spousal expansion. However, if we did account for the shelter costs, then there could be, then we might have to look at this differently. With the rent, condo fee, and standard utility allowance, so we're adding in rent here in this case, so we're changing it up a little bit. We get total shelter costs of $2,575 in this case. So we would have a shelter surplus in this case of $1,781.87. So our new MMNA calculation would be that shelter surplus, that excess shelter, added to the minimum MMNA, and we get $4,425.62. Now, again, as you know, our max MMNA is $3,948. So we would still use the max MMNA of $3,948. And with that being greater than the combined income of both spouses of $3,000, this would be a scenario where they could expand the shortfall, or they could expand the resource allowance because that shortfall of $948 needs to be made up. So by requesting a fair hearing, doing something like that, you could potentially provide expansion there. So yeah, I think that's pretty much it for the presentation here. This definitely, I hope, kind of highlights and shows how important and impactful the shelter standard, shelter expenses, and the minimum monthly maintenance needs allowance might be, and how the different ways that how that can really impact your plan from a case-by-case basis. So I'll go ahead and turn it back over to Amber, and we can field some questions that may have come up at this time.
Sure. So we have a couple of questions here. Somebody is asking what a promissory note is, and it appears as though it's a question from somebody that resides in a state that promissory notes are not a viable planning tool. So I don't know that that question is all that relevant, but the note is basically a way, instead of using the annuity to make a loan to a family member and then pay that back to either the Medicaid applicant or the community spouse, but not all states allow the promissory note as a planning tool to be used, whereas most of the states are going to allow for an annuity to be used versus the note. Another question is related to whether fees are charged on all annuity contracts. Stuart, did you want to take that question?
Sure. Yeah. The fees would only be applicable on cases where the annuity term is less than 48 months. So in that example that I gave you for the 12-month and 24-month annuity, there would be a fee associated with that. Whereas when you get to the 48-month and the 120-month terms, there would not be a fee with those annuities.
Okay, great. That looks like the only other question that we have, but Stuart, your contact information is on the screen. So if anybody has any follow-up questions, feel free to reach out to Stuart directly or call our office as well with any questions or send an email. Stuart, did you have anything else to close out with? Otherwise, I don't have anything.
No, I don't think so. Just want to thank everybody again for being on the webinar. And then we do also have a QR code here that if you wanted to leave a review here regarding your experience with the webinar, please feel free to do so. But other than that, thank you again, and look forward to seeing you guys at the next webinar in August.
Awesome. Thank you, Stuart. Thank you, everybody, for your time. Have a great day.